gentlelady's time has expired. Now recognize the gentleman from Arkansas, Mr. Crawford, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Administrator McCarthy. I know this has been addressed to some extent, but I don't think it's been, I think we can take a little deeper dive on this issue with the grassroots campaign effort that took place in your agency, specifically prohibited by Title 18 of the U.S. Criminal Code. And I don't think we've gotten a satisfactory answer. Have you or your legal department made efforts before the grassroots campaign was undertaken to ensure the EPA staff is familiar with the kind of activity that's prohibited under the Anti-Lobbying Act?
We actually were following OMB guidelines relative to the use of thunder. Yes.
Okay. So that's even worse. If they've received training in the Anti-Lobbying Act and then engaged in lobbying?
We believe we actually followed those guidelines, yes.
Well, I think the GAO disagrees with that. And whether or not there's there can be an intent proven, the subterfuge and the optics of what took place there are certainly worth considering. I think that there's some valuable lessons here in the GAO's findings, not the least of which is that the administration and your agency is willing to go so far as breaking U.S. criminal code to push an agenda. We already knew that you were willing to go to great lengths to push that agenda, but this brings it into a completely different perspective. Secondly, the GAO findings tell us that these actions set a dangerous precedent for future rulemaking. So you've basically compromised the integrity of the rulemaking process.
Sir, they never indicated that we referenced any law.
I'm on my time right now, Administrator.
I'm sorry.
In the age of social media and electronic communication, it's deeply troubling that agencies are willing to use these tools to subvert the concerns of the affected public and drown out opposition to your own views. And it's obvious that you were trumpeting your own views and not taking into consideration the public's views when this is a public rulemaking comment period. So I don't know how, after all those revelations were made, did you expect us to believe that during the WOTUS rulemaking, the EPA actually took into account all the views by affected stakeholders, or were you just concerned about the views of your political allies? It appears to me that that was the case.
Sir, the GAO never indicated that we referenced a particular rulemaking. They never indicated that we said anything incorrect. They had one concern relative to anti-lobbying, which was a hyperlink to a program that we were touting as being really good. One blog from one individual in the agency out of thousands was done, and it referenced a hyperlink, and they could not go back and prove or disprove whether or not that NGO at some other place in their web page may have had an ability for people to contact Congress on other related issues or this one. So we are certainly sensitive to the fact that that hyperlink referenced an outside of EPA website. There are other agencies that flag that. We're considering and working with OMB on what we can do. But if you look at this, there was no intent and there was no lobbying on behalf on the part of the agency or a reference.
Okay, I think that we
effort.
can take this as an example and a validation of the fact that the rulemaking process is deeply flawed and needs to be addressed, because this kind of stuff to me is not reflective of the opportunity that should be granted to the affected stakeholders. Let me switch gears with you just quickly in the time I have remaining. I was just told yesterday that the EPA took action against a farmer who didn't comply with SPCC rules on-farm fuel storage by failing to have an SPCC plan for his oil storage tank that was 5,000 gallons in size. But the 2014 WRDA specifically says that EPA can only require compliance for oil storage tanks in excess of 6,000 gallons. Until such time as EPA completes its study and a new rulemaking process is undertaken. My understanding is that the study is complete, which recommends a lower exemption threshold, but the rulemaking is still not finished. So my question to you is, why is the EPA taking enforcement action against individuals who are not out of compliance? And isn't that a violation of the law?
Sure, I'm happy to look into it and get back to you. If it just happened yesterday, I'm really not familiar with it.
Well, is that kind of thing a regular practice by the agency?
I think we've actually been doing a very good job on the SBCC rules. Many of them, because of changes in threshold, like 96% of them are no longer impacted by this rule. And of those 4%, 97% self-certify. So we're doing pretty good.
Right. Do EPA agents take compliance actions like this because they know that farmers aren't willing to fight enforcement actions because it costs them more in legal costs than it would be to just go ahead and succumb to the EPA pressure? Am I off base in suggesting that?
I don't know why you are suggesting it, sir, but if that's your point of view, you can have it.
It is my
but
point
I
of
don't
view,
know
and it's the point
anything
of view
about
of
this
most people in
enforcement
my
action.
district who farm and are subject to EPA regulation. I yield back.
Gentleman yields back. Mr. Scott, 5 minutes.
Thank you, Mr. Chairman.